So it's this is a pleasure to be here. Thank you very much, and it's nice to, like Susan, it's nice to get an invitation to somewhere as nice as Galway. I have been here before, not to the university, but to Galway, about 13 years ago. So I'm finding nothing looks very familiar, but I'm going to rectify that by having a good wander around today and tomorrow. So as Brian said, it's so I'm here to as a comparative kind of approach to look at where we've gone right and where we've gone wrong in the UK with our regulation on surrogacy, which we've had for a long time. And so often the UK is held up as a paradigm example of good regulation of surrogacy and other forms of assisted reproductive treatment. So I think that is largely down to age. And there was a time when probably we were ahead of the game, but these days the legislation, particularly in relation to surrogacy, could be said to be fraying at the seams a bit. And so hopefully some of our experiences, plus some of the findings from this report that Brian mentioned, can help, could be addressed in the UK. I mean, I'm part of a reform campaign group in the UK anyway, but also inform possibly legislation for Ireland. So, that's it. Right, so surrogacy in the UK is not prohibited, but it has been regulated for over 30 years now, since the Surrogacy Arrangements Act 1985. That Act, for just a quick brief history, that Act was passed as a reaction to the Warnock Report in 1984, which was set up as a reaction to the developments in IVF and associated research. And that report came out quite strongly against surrogacy. There was a general gut feeling that surrogacy wasn't the right way to approach pregnancy. But it didn't go as far as recommending a ban of surrogacy, despite its concerns, because it wanted to avoid the taint of criminality on surrogacy families, and particularly surrogacy-born children. But it did want to discourage the practice of surrogacy, and so that is very much what the Act reflects. The 1990 Act, the Human Fertilisation and Embryology Act 1990, added a bit to the regulation of surrogacy, specifically inserting a new clause that all arrangements were unenforceable, so there's no surrogacy contracts in the UK, and creating the parental order mechanism. So what we have, and that Act was amended a bit in 2008, just bringing it a bit more up to date, extending who parental orders are available to, including unmarried couples and same-sex couples in civil partnerships at the time, and then in 2014 that was extended to gay married couples once we allowed gay marriage. So what we have overall is that surrogacy is permitted but discouraged. Interestingly, payments between surrogates and intended parents, the surrogate can receive a payment from an intended parent. It's not illegal to do so, but the arrow there I'll explain in a moment. All agreements are unenforceable. What the law does ban, in fact makes a criminal offence, are commercial agencies and advertising. It is illegal to advertise for or as a surrogate. It is illegal, carrying fines and potential prison sentences, to broker an arrangement for money or to operate as a commercial agency. The law also states that the surrogate is the legal mother and no other woman. It's quite specific about that. And where she is married, or in a civil partnership or something like that, her spouse or partner will be the second parent. So what we found a little recently is that intended parents are seeking out unmarried surrogates for that reason, because it makes the process to achieve their own legal parenthood a little easier. So this rule that the surrogate is the legal mother applies wherever the arrangement is entered into. So no matter what the birth certificate you obtain from California or India or wherever says, that is our rules. And we found to an extent that people are a bit unfamiliar with that. Intended parents can obtain this order from a court, that is a parental order which transfers legal parenthood to them. but not everybody is eligible. There are very sort of tight rules on that, some of which I'll talk about a bit later. The arrow comes back to the thing about payments. While they're not illegal, the potential sanction for for having paid for your surrogacy is that a parental order, in theory, according to the words of the legislation, might not be granted. So that is taken into account as part of the welfare of the child assessment there. So that's what we have, but over this same timescale, this 30 plus years of regulation, the whole landscape of surrogacy has changed entirely. You know, in 1985 there was no internet, and there weren't cheap flights to all kinds of places, and so what we found is that other nations have opened their borders, opened their clinics, even providing what is essentially a package holiday deal to go get surrogacy overseas, and making that attractive. And despite the prohibition on advertising, I was at a conference last week where I think we could safely say that was being that was being broken, while there were people there with stands, you know, come to our clinic in Mexico, which looked quite a lot like advertising to me. So it does happen, and with the internet you can hardly police it, really, because people only have to do a few keystrokes and they found surrogacy somewhere that they could access. So there's been this big increase in cross-border arrangements, and aside from potential ethical concerns about some of these international practices and the way they're organised, this also brings, or has brought, definitely practical problems, including problems acquiring legal parenthood, problems with immigration, citizenship, and all kinds of other things. So we've got last 4 or 5 years, we've got loads of cases going through the High Court, which are highlighting many of the problems with the regulation of surrogacy as it currently stands. Mainly, these are all to do with parental order applications and whether or not the court can find a way to grant a parental order, despite there having been something that might look problematic. So if it's an international arrangement that is almost always commercial, there is almost always payment involved, and all that kind of thing. There's also quite a lot of cases about citizenship status and immigration and various things going on in that. But what we're finding is that judges are, in the best interest of children, making decisions that grant these children, grant the intended parents legal parenthood of their children for the children's sake. And they're making quite strong comments to that effect, like, why wouldn't I grant this order? Because not to do so would not be in the best interest of these children. So what we're seeing is a lot of retrospective authorisations of payments to surrogates or agencies, which the statute does allow. And we've seen a few cases where the time limit, there's a statutory time limit of 6 months within which you have to apply for a parental order, and we're finding judges are just extending that, so essentially there is now no time limit under which an application can be made, in effect. So one thing we have hit a bit of a barrier with, the judges have been making these quite progressive decisions, and we had an application by a single man for a parental order. We had 2 cases last year, one where a single man adopted and there was all kinds of complications arising from that, and another where one applied for a parental order. And the tone of the judgment is very much, well, I'd like to do this, but I can't, because the statute is clear, only a couple may apply for a parental order. And so that was denied on that basis, and, however, is being challenged on a human rights, a discrimination kind of basis, with a hearing on that due in May. So we'll watch this space, really. So then you get high-profile media coverage of times when surrogacy goes wrong, and wrong in all kinds of different ways. I mean, the assumption, I think that Susan mentioned, is that relationships break down, and intended parents might not get the child that the surrogate has, in effect, promised them. But that is so rare as to be just complete a myth part of this thing, and that this report that we were looking at is doing. But what you do get is problems surrogacy going wrong in different ways. So there's just recently been a case about 2 children born to a surrogate in India, which because of various things about paperwork and the surrogate's documentation, she was widowed and couldn't find the documentation to prove that. And then the passport office in the UK not issuing passports for the children. These children were stuck in India, being looked after by nannies because the intended parents had to work and look after the older sibling for more than a year. And so the courts have been quite scathing about that, saying, well, you know, something needs to be done in order that this kind of circumstance isn't arising. So there's all these kind of concerns about both the ethics and the practicalities of international commercial surrogacy. And so for a long time I've been wondering about why people go overseas. You know, what is it that draws them there? And also being troubled by the kind of numbers that were being suggested were doing so. And serendipitously, I was invited to join this Surrogacy UK working group. Surrogacy UK is a not-for-profit surrogacy agency, an introduction kind of place, a bit like a dating agency, where you meet potential surrogates, potential intended parents, and if you get on with them and everything goes swimmingly, you might enter an arrangement. So as a group, we wanted to try and get a picture, a better picture of various things. What kind of payments were being made, what surrogacy actually looked like, the number of intended parents going overseas for surrogacy, and why they might not enter an agreement at home. And this all came about after a debate in Westminster Hall, the sort of side part of our Parliament, where Jessica Lee MP, as she was then, cited a figure of 1,000 to 2,000 children being born annually to intended parents from the UK overseas. That many annually, with 95% of those being born from overseas arrangements. So that's quite a lot, but it didn't reflect our, gut instinct, our experience, and not Surrogacy UK's experience at all. So we set up this working group and published this report last November, which is the sort of preliminary findings of what we've been doing. What we wanted to do was hear the voice of those involved, to which end we ran a survey, which I'll talk about in a moment. We wanted to interrogate some of the surrogacy myths, some of which Susan's already talked about in a different context, and we wanted to consider formally, in a sense, whether there was a need for legal reform. And so we looked at all our survey responses and we did a long sort of case analysis. We also considered data from the Parental Order Register, CAFCAS, which is the advisory service to the family courts, the Passport Office, which issues passports to children born overseas, and the Ministry of Justice, among various other sources. And we found nothing that could support either the cited number of annual surrogate births overseas, but what we did find was that the proportion of the total amount of surrogacy being undertaken overseas was increasing year on year. What we did discover is that all the data sources are incomplete in some way. They all record data differently, so different timescales, different parameters, so there's all this kind of weird overlap, and what it means is that it's really hard to get a picture of exactly how much surrogacy is going on and how much of that is going on overseas, particularly as it is not a legal requirement to apply for a parental order. So there will be people who have come back from overseas or who have done it domestically who haven't ever applied, and so they're not showing up on any of these registers anywhere. So we wanted to try and get to the truth. We haven't got anywhere near the truth, so I can't present you accurate data, but we're going to continue working on this, continue working on the numbers, and part of the campaign is to regularise the reporting of this somehow. So what we concluded is that root and branch reform of surrogacy law in the UK is needed. The time has come, and we made a series of recommendations to that effect, all of which are based on the primary concern of protecting the welfare of children specifically and children generally born through surrogacy. So, as I mentioned, there was this survey which we ran last year, June to August. We were amazed to get 434 responses. So we sent this out We send it out via the Surrogacy UK membership, also through COTS, the surrogacy agency that Susan mentioned. Also, we had contacts on what are called indie websites and indie forums on Facebook and other places where independent surrogates, I don't want to use the word advertise, but advertise, that they might be available to enter surrogacy arrangements. We put it out on the HFEA, the regulatory body's website, via a couple of charities we know, sent the link to the survey out. And so, what we can say is it's not perfect. We've got a lot of responses, which is great, so we've got a lot to play with. But largely we're talking about self-selecting people who've been sent the link. So it does have flaws, I guess, in it that way. But of the 434, we had 111 surrogates, which is way more than we've seen surveyed in any sort of groups like this before. The Brazier report of 1998 only had about 35 or 38 surrogates on it, so and that was a recommendation to government. So we are counting ourselves lucky. We had 206 responses from intended parents. 65 of that, 206 were gay males, and only 19 of whom went overseas. What we don't know about our intended parents in the survey, because the thing's totally anonymous, is how many of them are paired up. And we don't know who matches which surrogate, although if we dig deeper, we might be able to find out that some of these surrogates match some of these intended parents. There's all kinds of different things going on there. Some of them have done it 2 times, 3 times, 4 times. One of the surrogates had done it 9 times, and had 5 children of her own. So, there's some serial surrogates out there. We had surrogates who were family members, surrogates who were complete strangers, surrogates who were friends, surrogates who did it because they had their own experience with fertility problems, or they knew someone who had, or all kinds of things in the background there. And there's loads more to come out of the data that we've got. We had, of the 434, 112 were others, 9 clinicians, which is kind of nice to hear from them, 9 lawyers, 6 social workers and 15 academics or researchers, though they haven't specified what area they're researching. The remainder of that 112 are largely friends, family members of people who have, of intended parents who either have gone or are going through surrogacy, so are involved in that way. And there were a lot of people who knew already that they would need to use surrogacy in the future. There was a big representation, it must have been sent to a particular group, a support group for women who were born without a womb, a particular condition there, and there were loads of those who said, well, the only way I'm ever going to have a child is to use surrogacy, and so I'm interested in this. So we've got loads more analysis to do, particularly on the free text comments, which there is loads of, but some funding would be nice if anyone's listening. But what I want to do today is present some of our sort of main findings, and some of which definitely mirrors what Susan's found in some of her work over time. So as you can see, we found a really high number, and like I say, these are self-selecting survey respondents, but we found a really high level of ongoing contact between surrogates and the families they help to create, according to responses from both surrogates and from intended parents. So you see it's up in the 90% say that they maintain contact. And this is, they say they maintain contact, and that again varies. It might be a Christmas card and a birthday card, or it might be, some of them are godparents to the children that they gave birth to for someone else. There's lots of that going on. Some of them meet up monthly. There's some of them, there were some people you sort of got an intuitive link between the various families. Some of them said they went on a biannual trip. Them, another surrogate, and the 2 families that they helped to create all go to Centre Parks together twice a year and party it up for a weekend. So all the kids together and everything. So, there's various levels of contact, but high levels of contact. And even, we were quite surprised, 69% of the intended parents who went overseas maintain contact, although that does seem from the free text comments to take a different form, just emails, pictures, bit of Skype going on. On openness, on telling, on what they say that the children know, 39 of the UK, the intended parents who did surrogacy in the UK had already told their children how they were born. And the red numbers here are of the 19 people who went overseas. Only 3 of the 19 who went overseas had told their children about the circumstances of their birth. 140 had said they will tell in the future, but the age ranges of the kids we're talking about, the youngest was 4 days. So there were quite a lot of very young children who might not have been told yet. 3 were undecided, and in all of the groups, the most appropriate age that they considered for telling would be preschool, 0 to 4 years. And many in the free text comments were saying things like, we just always talked about it, just in conversations, just making sure they hear, none of this sitting down and making sure, just so it's normal, it's just their everyday life. So there's quite a lot of that. On parenthood, by which I mean legal parenthood, near enough 65% of the surrogates said they thought the intended parents should be the legal parents, even if they weren't genetically related. So 65% of surrogates, denying a claim to their own potential legal parenthood. Only 4 respondents said it should be the surrogate who is the legal parent. So that's the total opposite. That's 4 of the 434 said it should be the surrogate. And there's sort of a lot more on that to come. On money, we asked how much it cost. So the surrogates answered. The chart here is about the surrogates and what they said they received in form of compensation. So you can see the vast majority were in the £10,000 to £15,000 compensation segment, and sort of 68% of them did that. 104 surrogates answered this question, so there were 7 who didn't. 29 surrogates received less than £10,000 in compensation. Some of them received 0, or some of them said, just reimbursement of my train fares and things like that. But you did have the odd sister or cousin or best friend or something doing that, and for literally no money. Which is interesting in terms of the fact that what we're allowed to do is reimburse expenses. You would think expenses would be fairly constant across the board. So it might be that people are just reflecting on that differently. So even when a sister undergoes IVF surrogacy for you, there's going to be expenses incurred. It's just they might be just thinking about where the money went differently. No one said they got more than £20,000. So it is a myth that people are doing surrogacy for money, or the people who are doing surrogacy for money or under the table payments didn't respond to our survey. There is that possibility too. On payments by the intended parents who use UK surrogates, the highest total cost, so that's everything, IVF, transport, accommodation, expenses to the surrogate, everything, was £60,000. So what we do know is surrogacy is can be pretty expensive. It wasn't uncommon for people to be saying £30,000, £40,000, that kind of thing, but no one said higher than 60. The sum that they said was paid to the surrogate ranged from 0, and again this is sort of usually family members, to £25,000. So what we have there is none of our surrogates went more than £20,000, so it might be that intended parent, their surrogate wasn't represented in our survey. But what we had was the mean average of what was paid to the surrogate, working out at just over £10,500, which does kind of mirror what the surrogates were saying. So there does seem to be a sort of price range of somewhere between £10,000 and £15,000 is commonly what surrogates are getting. Overseas, so we had these 19 respondents, which was just over 9% of our total respondents. But you'll notice if you do the maths there that that's 19 respondents with 20 different arrangements. So one of them had done it twice. So even though we don't think there are people going overseas in the thousands that have been cited, We don't think the proportion is this low, and we got some reasons for that in terms of our own survey. And that is that only one of the UK surrogacy agencies, the not-for-profit surrogacy agencies, works with overseas surrogacy, really. Surrogacy UK doesn't, COTS doesn't, but another one does. Also, there's this, he calls himself an independent facilitator of overseas surrogacy arrangements. He's a guy who went with his husband and had surrogacy in California. It cost him $300,000, and he didn't want people to have to go through that again. So he's now helps people. So he's a conduit. So he doesn't take any money from it, but he is helping people set it up. But he sent a link around lots of his contacts, but he came very late to the survey, which closed on the 20th of August, and he only got sending out links on about the 10th of August. So we did get a load of people who've been overseas then, and what I've got is a load of emails sat there saying, I missed the closing date, but if you want to interview me in the future, I'd be more than happy to tell you about our experience. So we will follow that kind of stuff up. So you see the destinations. 14 of the 19 did surrogacy in the USA, various places, not all California, which kind of surprised me because I know that's the destination of choice, particularly for gay males. 3 in India, 2 in Thailand, 1 in Nepal, but note that all of those destinations are now closed to people coming from overseas, with some, some inroads, like if you are an Indian national, you could possibly go to India, for example. So of our group of 19, we had 14 gay males, one of whom identified as a single man, and 4 intended parents in heterosexual couples. So you could surmise that overseas surrogacy is a more popular choice for gay couples, but again, the limitations of who responded and when and how on the overseas ones need to be borne in mind, and we will follow up with more, a similar survey, asking similar questions to more people who went overseas in the future. In terms of costs, significantly higher, obviously, because you're talking about total costs. So 14, remember the total cost for the UK, the highest was £60,000, but 14 of the 19 paid more than £60,000 in total. The highest was £130,000. And people are rounding things up, but it's about trips to wherever you're going. It's about payment to the surrogate, payment to agent. If you're going to America, you're factoring in health insurance costs, and all kinds of things, lawyers' fees, everything's included in that. But 14 of the 19 paid more than 60,000, and they were all the ones who went to the USA. The sum paid to the surrogate range from £4,000 in Nepal to £40,000 in one of the US arrangements, which says something generally when you start looking at the ethics of these things. And the mean payment comes out higher to the surrogates, 17 and a bit £1,000 compared to the 10.5 that surrogates are receiving in the UK. So there are some differences which might or might not feed into the ethical questions. So we asked about reform. We asked the whole lot about reform. So of this we got just under 400 responses, and 3/4 of them said yes, like an outright yes. There's a few possiblies in there, there's a couple of don't knows, but only 13 of the respondents said no, it doesn't need reforming, it's all right as it is now. That's just over 3%. So that helps our campaign a bit. In terms of who wants to see reform, the group with the highest proportion of respondents who wanted reform, you can see that the IPs overseas, you have 84.2% of them said yes, and there were only 19 of them, but 16 of them said there should be reform, which and looking at their free text comments as well and stuff we're going to follow up, it does suggest that perhaps legal barriers to successful surrogacy in the UK may be pushing some people abroad. And there have been some articles in the press to that effect over the last couple of weeks, including a sort of fairly high-profile celebrity chef basically saying the only reason he went abroad was because it was too difficult to work out what was going on in the UK. And it was made very clear how easy it was to go to America. So, as a whole, from the intended parents, UK and overseas, none of this is that surprising, given the sheer amount of free text comments we had indicating that intended parents felt badly treated by the system as a whole. So they're referring to midwives, Kafka's court reporters, the courts, the hospitals, doctors. There's lots of comments about nobody understands surrogacy. We're treated really badly. I wasn't allowed in the delivery room. All kinds of things like this. We were treated like criminals came up quite a lot. So there is this sort of perception that needs changing about surrogacy. But part of my research has been finding that the way the law is what creates the perception, maintains the perception, and then it all feeds back into itself. So the key reasons why people were thinking that the law needs to change were that it was out of date in terms of modern society and the acceptance of different family forms. There was a perceived need for increased transparency about the system and openness that surrogacy happens and it can happen well. There's a need to discourage people from going overseas. This is what our respondents are saying. And a feeling that the law just does not reflect the realities of surrogacy in terms of ongoing contact and the fact that people feel proud and happy about what they've done. And a big chunk of people saying it just needs to be changed because it doesn't reflect properly who the parents of the child are. And so if you want to look at the report, Appendix 2 breaks all this down into various charts, who's saying what, but the agreement is generally kind of across the board. So obviously I agree, the law's 30 years old, it's definitely increasingly out of date, it's sort of creaking a bit, and although some modernising has taken place, a greater breadth of people can apply for a parental order, there's still these sort of weird arbitrary limits in it, which we would like to see got rid of, and in particular I'd like the presumption of maternity to be reversed. That would be my starting point, and if we couldn't have that, then I'd like a kind of pre-birth parental order to be put in place in order that the children can have the intended parents recognised as their legal parents at birth. So just picked out a few specific aspects of reform that people commented on. So the statements in the boxes are literally statements that we had in the survey that we asked people to strongly agree, they were neutral on, they could disagree or strongly disagree. You've seen those kind of things. So statement 1, that the current system does not assign parenthood to the correct parties from birth. There was a majority agreement in all groups, surrogates, intended parents and others. I've sort of forgotten the others as we go through this, but it was, very much, you can see the bar charts and they're all over one side. So the surrogates, there were 104 responses on this, 65 strongly agreed, this was the case, and 25 agreed. 3 disagreed and only 2 strongly disagreed. So there's only 5 of the 106 surrogates there, 104 responses on that one, who are saying, no, the law is okay as it is in terms of parent. So what we're taking from that is that surrogates do not want to be recognised as the legal mother. They don't think they should be. They don't think they are. And in talking to surrogates and from some of Susan's research, there is very much that feeling about, their bun, my oven, kind of thing. And there's lots of comments about I was only babysitting and things like that. And so there is this general feeling that they're just not the mothers of those children. And there's a fear among them. So everybody the law is premised on this myth, I think, that surrogates are going to be the ones that change their mind. And they can walk away with the baby, and it's the intended parents who should feel frightened that would happen. There's loads of comment in there that suggests it's equally as bad, if not more, the other way around, that surrogates are frightened that the intended parents will change their mind and they'll be left with a baby they didn't want, and sometimes might not genetically be theirs at all. Similar numbers came out for the intended parents in all groups. There were only 2 who disagreed about the parenthood status and only 1 who strongly disagreed. Less surprising, perhaps, because the intended parents want to be parents, But there are 3 of them out there, of 3 of 206, who think the law is right as it stands, that the surrogate ought to be the mother. From the others, we thought there'd be a lot more variety here because they're not surrogates or intended parents. We again only had 4 disagree and 2 strongly disagree about the parenthood assignation. The biggest difference we found, in the bar graph, is that there were 11 of them all who didn't wish to answer. I don't know, or I don't wish to answer. There were no don't knows or don't wish to answer from the surrogates or intended parents. On the second statement here, that surrogates should be allowed to receive payments and not just expenses, there was, the spread of answers, they're all in bar charts in the appendices of this report. The spread's much more even, so it's not all going to one side. More surrogates disagreed and strongly disagreed than agreed. So actually the surrogates are saying, we don't want payments. We want it to be like this. And a lot of the free text comments are suggesting that if you allow payments, the wrong kind of people will be surrogates, and we're the right kind of people because we're doing it for not payments. For the reimbursement of our expenses, and that's perfectly legitimate. It's kind of the voice that was coming through there. Of the intended parents, 36 disagreed and 49 strongly disagreed. And that was the UK, but the majority of the ones who went overseas agreed that surrogates should be paid. So there is this disparity. If you go overseas, you probably paid, and you agree, therefore, that they should be paid. But the ones here were saying, no, it shouldn't. There was a lot of comment on tainting the relationship between the surrogate and the intended parents if payments were allowed. On the third statement about surrogacy contracts and enforceability, there was, again, this majority agreement. In fact, it was kind of overwhelmingly in favour, particularly the surrogates. The surrogates were overwhelmingly in favour that there should be enforceable contracts. And the intended parents were a bit less sure, but still pretty sure. 92% of the intended parents strongly agreed that contracts should be enforceable, with this caveat that is set where the best interests of the child are not met. So they're saying, they should the presumption should be that a contract should be enforced unless there is a reason for it not to be in this particular circumstance. So again, kind of reversing the way the court looks at these things now. Other interesting aspects of this, there was a strong support among all groups for a dedicated regulatory body to deal with surrogacy, kind of a mirror of the HFEA, but surrogacy specific, or an arm of the HFEA to deal with surrogacy. There was a push in the opposite direction about the question of surrogacy agencies being able to make profits. No one was very much in favour of profit-making surrogacy agencies, and the free text stuff was all about tainting what surrogacy is really all about, and it's about kindness and it's about altruism and all that kind of thing. So they're saying the non-profit agencies should continue to exist but should get help, should be able to at least recoup their losses or things like that, or be professionalised. Some of our judgments have suggested professionalised agencies, but not profit-making. There was a general feeling, but not quite so strong as some of these statements, that people should be able to advertise for or as a surrogate. So favour for changing that provision of the law. There was strong support among all the groups that single people should be allowed to become legal parents through surrogacy. And there was less strong, but still pretty strong support for what's called double donation, intended parents who produce neither the sperm or the egg. And so neither of them are genetically related. Currently, under the law, they can't apply for a parental order, but there was some support for that being changed. There's a very high level of support for the things on here, that parental orders should be able to be pre-authorised, for example, by a court. So instead of doing it after the birth of the child and maximising the disruption and the settling in and the bonding and whatever, and the risk for intended parents, that they should be able to be pre-authorised if such an order is going to be kept, rather than just a reversion of the presumption, so that they become effective at birth. So the intended parents are the ones who register the child's birth, and all those kind of things. So they just proceed as a normal family would. Lots of the comments said that. And there was a very high level of support for legal parenthood automatically resting with the intended parents at birth. So again, it's a sort of best case and second case scenario. Our recommendations, as you can probably imagine, are that there's no question that reform is needed. We don't think that anyone should rush into this, even though obviously we think we've got all the answers. We probably haven't. We think reform should centre on the welfare of children and families created, but Susan's research is excellent for us in that regard, in that we can support it by saying that surrogacy created families are doing really well. And that's probably against the assumption that a lot of people have. We know that data is inadequate, and we need to address this both before and subsequent to any reform. How that data is collected needs to be reviewed. What is collected, where it's collected, and how it's collected needs to be reviewed. We should look at, and one of the things we say is potentially that there should be a public consultation. So if there is, then perhaps some of the voice of these people will come through, even more than it already has. We'd like to focus on why people go overseas for surrogacy, despite the risks. And risks we're talking here is not the risk of not coming home with a child, because that seems to be a relative certainty, and that is in fact the reason why lots of the people who went overseas said they did it, because of the certainty that they would actually get the child that they longed for. The risks being you might not get a legal parenthood, you might end up having to adopt a child that is genetically yours, you might have immigration problems, you are going to end up spending loads of money. All the sort of legal and practical risks that go with the overseas surrogacy arrangements. Also, there was some concern, so there weren't many who went to India and Thailand and Nepal in that sample, but there was some concern expressed by the people who had done so just about it. There was one comment said it all felt a bit dirty for a while, which isn't something you really want to see. So they're kind of saying in the big paragraph they put there, we got over it in the end, but it all felt a bit weird, which you don't really want it to be like that. So given the high support among surrogates and intended parents for there not being payments, we think reform should look at promoting surrogacy as a relationship, an ongoing relationship, which seems to be happening anyway between surrogates and the intended parents and the children, and not a transactional arrangement. That we should continue to allow compensation or reimbursement for surrogates, but not payments, but that we should be a bit more transparent about what's included in that, and a bit less, have that less of a gut reaction that some things can be expenses and other things can't. Is compensating for time and inconvenience a legitimate expense or not? Egg donors are compensated for their time and inconvenience at a very low level, but if you work out the sort of differences in time, then perhaps £10,000 to £15,000 isn't quite enough as an average. Who knows? But I think it needs to be looked into. There needs to be much more transparency, and if that happens, there might be less danger of there being under-the-table payments being made. We think that intended parents should be recognised as parents at birth. We think automatically, but if there has to be a parental order mechanism, then we think that should be a pre-birth authorisation. We think single people and those who use double donation ought to be the legal parents of the child that's created through surrogacy. Essentially, we're talking about intentional parenthood. That those who, but for, legally speaking, but for their intentions, but for their actions, this child would never have come into existence. And there's lots of hurt in the responses to surrogacy. There's people who've had, we had 8 failed attempts at IVF, or we, had IVF and the first time didn't work and the second time I miscarried. And there's lots of sort of horrible histories that explain why somebody has ended up at surrogacy. And I think people with their gut instinct against surrogacy kind of forget some of that stuff. There was literally no evidence that anyone had done it for any kind of convenience or vanity reason or anything like that in here. We think that the advertising and agencies rules should be a bit relaxed, and we think that the state agents that are involved, currently the Department of Health, Ministry of Justice, CAFCAS, the courts, should all produce better, clearer and joined-up guidance. One thing I can report on happily is that CAFCAS have met with us and taken on board what we've said, and they've had a good look at some of our free text comments that were directed specifically against CAFCAS and their involvement, and they've changed and updated some of their materials that go to health visitors, court order reporters, and on their website more generally as the basis of some of our findings. The work is ongoing. I'm continuing to work on this. We are continuing to campaign for this. There's a web link there, which I don't know if these slides are going to go up anywhere, but if they are, then you can click through this link. And there's also a conference I'm organising for anyone who can make it to London on the 6th of May, actually looking at legal reform. Susan's speaking at that one too. Thank you very much.